thought he was going to die when his mother was at him.
The involuntary manslaughter now sentences you to 2.5 years.
Inflicted all those injuries and damage. That's not a reasonable doubt.
Tommy Vladimir Alvarado Ventura is a 31-year-old man from Hempstead, New York, who was born in El Salvador. He is part of the MS-13 gang and has been deported from the U.S. 4 times.
He was deported in 5 years, 4 times. And since 2011, he's wandered the streets of Nassau County, free. And that is deeply disturbing. You have a little baby who, just talking about this makes me nauseous, a little baby who will never ever recover from the injuries she's recovered at the hands of this monster.
On March 22, 2017, Tommy Vladimir Alvarado Ventura was at home in Hempstead, New York, taking care of his girlfriend's young children with another person while the mother was at work. Around 12:30 a.m., he left the apartment and went to a bar. At about 2:20 a.m., he got into an argument with a 24-year-old woman over buying cannabis. The argument turned violent when he confronted her in a parking lot, punching, kicking, and attacking her with a sharp object multiple times, causing serious injuries, including a collapsed lung. She was rushed to the hospital. Alvarado Ventura returned home around 3:15 a.m. After his girlfriend got home, she noticed severe injuries on their child and confronted him. The argument escalated, and he punched her before grabbing a knife and attacking her multiple times. He was arrested and charged with child abuse, attempted murder, and criminal possession of a weapon. Alvarado Ventura pleaded not guilty and was denied bail. His lawyer refused to comment on the case. He has a long criminal history, including arrests for drunk driving, abuse, and contempt of court. He was first arrested in Texas in 2005 for entering the U.S. illegally and deported in 2006. He was deported 3 more times after being arrested for other crimes. Michael Sykes is responsible for one of the most shocking crimes in Staten Island in 2016. In a violent rampage at a Ramada Inn, Sykes brutally ended the life of his girlfriend, Rebecca Cutler, and 2 of her young daughters. His motive for the attack was jealousy. He believed Rebecca had been cheating on him after finding text messages from another man on her phone. On that tragic day in February 2016, Rebecca and her 3 daughters, Ziana Cutler, Malaya Sykes, and Miracle Cutler, were staying at the hotel where the Department of Homeless Services had placed them temporarily. In a violent outburst, Sykes ended the lives of Rebecca, Malaya, and Ziana in an unimaginable way, leaving Miracle as the only survivor of this horrific event.
He had an attitude, like he was frustrated with something.
His face is like he's angry. You didn't even want to look at his face the way he looked.
Michael Sykes first attacked Rebecca Cutler, the mother of his child, inflicting multiple wounds with a sharp object. His violence didn't end there. He also attacked her 2 daughters, Ziana and Malaya, and both girls tragically passed away in the assault. In a heartbreaking turn of events, Miracle Cutler somehow survived the attack, despite suffering multiple wounds.
Find him going into the room about 8:50 in the morning. He leaves about 4 minutes later, so we believe that's when the attack happens. He then goes on, gets on a bus, and takes to Staten Island Ferry.
We want to get him. We want to get him very, very quickly and get him off the streets as fast as we can.
In court, prosecutors showed how Michael Sykes' rage led to the crime. The extreme violence and coldness of his actions shocked everyone in the courtroom.
I will tell you why that man killed Rebecca Cutler. And it got to the boiling point for him when he took that phone. That is why he killed. He said that man sitting right over there, that loving, caring, doting father, is guilty of all the crimes charged.
Michael Sykes' lawyer tried to shift the blame by arguing that the facts didn't completely back up the prosecution's claims, but the evidence against him was clear. At one point, even Sykes' own mother testified that he had admitted to the crime during a phone call. Throughout the trial, the emotional impact on the victims' families was visible. Rebecca Cutler's relatives cried in the courtroom as they heard the disturbing details of the crime. Rebecca's sister, in particular, struggled to deal with the loss and the horrifying truth of what had happened. She asked the court not to let Rebecca down, urging for Sykes to receive the harshest possible sentence.
We implore you not to let Rebecca down as you consider the sentence. The request of the family is that the maximum penalty for the crime for which the defendant was convicted be imposed.
For Rebecca Cutler's family, justice for her and her children was the only way to find any closure. The jury convicted Michael Sykes, and when it was time for sentencing, the judge was firm in their decision.
Each and every child numerous times. Your daughter was alive in that room when the room was opened and the massacre was revealed. Your daughter lay in that room for an hour, alive, but with her life slowly fading away. You have never shown an ounce of regret. You have never shown an ounce of sorrow. The only person you've ever been concerned with is yourself. You failed as a husband, you failed as a father, you failed as a human being. In my opinion, based on what you did, you do not deserve to ever see the light of day.
The judge made it clear that Michael Sykes would never be released, sentencing him to life in prison without the possibility of parole.
So accordingly, your sentence on count 2 of the indictment, murder in the first degree, for killing Ziana Cutler and the others named therein, is a sentence of life without parole.
The message was clear. A person capable of such a horrific crime should never be allowed to hurt anyone else. This is Miranda Caceres. She was convicted of starving her stepson, Benjamin Serra, leading to his tragic loss. After deliberating for just under an hour, the jury found Miranda Caceres guilty of injury to a child with serious bodily injury by omission, a charge that could result in a sentence between 5 and 99 years. The trial focused on the circumstances surrounding Benjamin's tragic loss and Miranda's actions leading up to his passing on August 17, 2021. Initially, Miranda did not testify, but she later took the stand during the punishment phase.
You will not take responsibility for any of it. Correct?
I never caused those injuries.
Again, you're not taking responsibility for any of those injuries, correct?
Yes, because I never hit him.
Who caused those injuries to Benji?
Dad.
Is this from the gate incident too?
No, the belt.
As Miranda Caceres recalled finding her stepson gasping for air, her emotions overwhelmed her, and she broke down in tears, shaking with sorrow. She expressed profound regret, saying she had wanted to take her own life after Benjamin's demise. Afterward, she was admitted to a psychiatric facility for help. The prosecution painted a grim picture of Miranda's treatment of Benjamin, presenting disturbing evidence, including video footage of him crying and begging for food, along with images of bruises on his frail body. Prosecutors argued that Miranda deliberately denied Benjamin food and water, leading to his severe malnutrition and ultimately causing his tragic loss.
The system failed Benji. I don't put it any other way. Police failed him on July 20th of 2021 when he was already clearly being starved. CPS failed him. But that's why we have the criminal justice system. That's why we have 12 members of our community, is to vindicate his death. There's been straps placed on there to prevent the child, Benjamin, from getting inside the pantry, from getting inside the fridge to get any.
It was pointed out that at just 4 years old, Benjamin weighed only 28 pounds, a clear sign of extreme neglect. In her defense, Miranda's attorney, Anthony Cantrell, tried to present a more nuanced view, arguing that she was not the monster the prosecution depicted. He stated that the family had sought medical help prior to the loss of Benjamin, and emphasized that Miranda was a loving mother doing her best under challenging circumstances. The defense also suggested that Benjamin's passing could have been caused by undiagnosed type 1 diabetes, along with cerebral edema, as argued by a forensic pathologist who testified on Miranda's behalf.
He died from starvation. Benjamin Severa most likely had autism. The history is there. It's confirmed by April and Brandon that he hits his head. This might have caused or contributed to its death.
However, the defense's argument struggled to convince the jury. A key moment came when Benjamin's 12-year-old brother testified, sharing upsetting details of abuse by Miranda.
He will get mad whenever he spills stuff or he does something on accident. Miranda will grab Benji and throw him up into the air and make sure he falls down on the ground. And it will hurt Benji. She will usually force Benji to open his mouth by grabbing his mouth and trying to open it. And Benji will usually cry because it hurts, and then this hand sanitizer tastes bad.
Did Miranda ever tell you to keep what she did to Benji a secret?
Yes.
How many times?
A lot of times.
He also testified that at mealtimes, Miranda would not let Benjamin eat with the family and would often lock away food to keep him from getting it.
Miranda put all locks all over it. The fridge, the counter, everything.
In the end, the jury found Miranda's defense unpersuasive, leading to her conviction. She was sentenced to 25 years in prison without the possibility of parole. In 2014, 15-year-old James Fairweather murdered 2 people, James Atfield, a 33-year-old father of 5, and Nahid Almania, a 31-year-old student from Saudi Arabia studying at the University of Essex. Fairweather had a troubling interest in serial killers and a history of behavioral problems, including being cruel to animals and being obsessed with violence. He was bullied at school, had low self-esteem, and struggled with undiagnosed dyslexia, which wasn't discovered until after his arrest. The tragic loss of his grandmother in 2012 also deeply affected him. In January 2014, Fairweather was convicted of robbery and put under a year of supervision. He was also found guilty of damaging property in 2013. On March 29, 2014, Fairweather attacked Atfield, who was lying drunk in Castle Park. Fairweather attacked Atfield over 100 times, targeting his head, face, and torso. Atfield had defensive wounds on his arms and hands, showing that he tried to fight back during the violent attack.
Saw him. It was laying on the grass, like that. It was like just fast asleep, where he was drunk. So I went up to him. Can I stand up? Like, yes. Went up to him. Stood over like that. Not helping that.
3 months later, on June 17, 2014, James Fairweather murdered Nahid Almania as she was walking to the University of Essex.
It's been murdered in a way that can only be termed a brutal and savage attack. There are some obvious similarities between her death and that of James Atfield, who was death in Colchester on March 29th.
In May 2015, James Fairweather was arrested after a dog walker spotted him hiding in bushes near the same area where he had attacked Almania. During his confession, Fairweather revealed that he had been hearing voices urging him to take lives.
Voices were talking to me, you need to make a sacrifice or we're going to come and get you.
Fairweather described encountering Atfield while he was asleep and attacking him, as well as approaching Almania and injuring her fatally. His defense argued that autism, paranoia, and the voices he heard led him to commit the murders. However, a psychiatrist questioned whether he was truly suffering from psychosis. In January 2016, Fairweather pleaded guilty to manslaughter, claiming diminished responsibility, but denied the charges of murder and carrying a weapon. The Crown Prosecution Service rejected his plea and continued with the murder charges. In April 2016, Fairweather was found guilty of both murders and sentenced to life in prison with a minimum of 27 years. He was 17 years old when he was convicted. Although women aren't exempt from committing crimes, it is particularly shocking when a cannibalist like Catherine Knight and her horrific crime come to light.
Deep down, I think that he knew it was going to happen. He knew.
Let's take a look at the Supreme Court of New South Wales in Australia, where Catherine Knight's crime is unfolding and her sentencing awaits. On February 29, 2001, Knight, an Australian abattoir worker, brutally attacked her partner, John Charles Thomas Price, 37 times. She then dismembered him, cooked his body, and planned to serve it to his children. To understand how such a horrific crime occurred, let's look back at Catherine's troubled childhood. She was born into a dysfunctional family with an alcoholic father, an abusive mother, and was assaulted by family members until she was 11. She left school at 15 and sought what she considered her dream job at a local abattoir. Throughout her life, Catherine had toxic relationships with men who couldn't handle her abuse, and they often left her. In 1995, she moved in with John Charles Thomas Price, and their relationship was also violent. It escalated so much that in February 2001, Price filed a restraining order after Catherine wounded him in the chest during an argument. He even warned his co-workers that if he didn't show up to work the next day, it would likely be because Catherine had taken his life. Despite the warnings from others, Price returned home, fearing Catherine might harm his children. That same day, Catherine injured him multiple times, removed his skin, and hung it on a meat hook. On November 8, 2001, Catherine Knight was sentenced to life in prison without the possibility of parole. Victor Antonio Martinez Hernandez is accused of murdering Rachel Morin in Harford County, Maryland on August 5, 2023. Rachel, a 37-year-old mother of 5, went missing while walking on the Ma and Pa Heritage Trail in Bel Air. Her body was found the next day, and investigators discovered she had been assaulted, with multiple head injuries and bruises all over her body. Her passing was attributed to strangulation and blunt force trauma. Martinez Hernandez, who was 24 at the time, faces several charges, including murder, third-degree assault, and kidnapping. Authorities believe he attacked Maureen on the trail and then left Maryland. Martinez Hernandez, a suspected gang member with a history of violence, is also wanted in El Salvador for the murder of a woman in January 2023. After that crime, he fled to the U.S. and committed a home invasion in Los Angeles, where he assaulted a girl and her mother. He lived with family in Maryland from December 2023 to May 2024 before being arrested in Tulsa, Oklahoma on June 14, 2024 after a 10-month search.
This day, I'm here to tell you Rachel's murderer is no longer a free man.
Authorities suspect him of being a serial killer because of his alleged crimes against women in both Central America and the U.S. If convicted of the Maryland murder, he could be sentenced to life in prison without the possibility of parole. This is Michelle Carter, who in 2016, at 17 years old, was convicted of manslaughter for encouraging her boyfriend, Conrad Roy, to take his own life through her words alone. Although she wasn't physically there, the court decided that her persistent messages influenced Roy's decision to end his life, making her responsible for his tragic loss. In court, Michelle Carter was sentenced to 2.5 years in the Bristol County House of Corrections for involuntary manslaughter, with 15 months to be served and the rest of the sentence suspended. Judge Lawrence Moniz handed down the sentence, allowing Carter to remain free while she appealed. This decision followed heated arguments from both the prosecution and defense. The prosecution asked for a sentence of 7 to 12 years, arguing that Carter's actions were reckless and selfish. They claimed she pushed Conrad Roy to get back into his truck, even though he was scared and unsure about going through with his suicide. Prosecutors pointed to her texts and phone conversations with Roy, saying Carter manipulated the situation for her own gain and had not taken responsibility for her actions. Listen as investigators question Michelle Carter about her boyfriend.
On October 2nd, we're talking to Michelle Carter at King Philip High School. Michelle, the reason why we came out here is because we were looking into Conrad's unfortunate passing. We did determine a little bit that you probably had a lot of contact with him.
Yeah.
Do you think you had contact with him that day?
I think so.
Yeah.
I was talking to him on the phone like the night before the 12th, and we were talking, and then like the phone like hung up, but I didn't really think anything of it. I had a feeling like if he didn't get help, then something was gonna happen, and I was trying to get help for him sooner. I like wanted him to go with me, and I should have done something sooner, but by the time it was just too late.
Conrad Roy's family made emotional statements in court before the sentencing. Watch as his sister tearfully expresses that her brother will always be with her.
Not a day goes by without him being my first thought waking up, and my last thought going to bed. Throughout those 13 years with him, I have countless amazing memories that will always be with me.
His father, Conrad Roy Jr., spoke about the grief and pain his family has endured since his son's demise.
Michelle Carter exploited my son's weaknesses and used him as a pawn in her own well-being. She has not shown any remorse.
Judge Moniz, in delivering his verdict, stated that Carter's actions were wanton and reckless, particularly highlighting how she instructed Roy to get back into the truck despite his fear and hesitation. He also pointed out that Carter did nothing to stop Roy's tragic loss, even though she knew where he was and could have contacted his family.
Having reviewed the evidence and applied the law thereto, now finds you guilty.
The judge said these factors were key to finding her guilty of involuntary manslaughter. Beate Schäpe was a member of a German neo-Nazi group called the National Socialist Underground, NSU. She was accused of assisting the group in ending the lives of 10 individuals between 2000 and 2007. Most of the victims were Turkish immigrants, but a Greek citizen and a German policewoman were also targeted. Schäpe was also involved in 15 armed robberies, arson, and 2 bomb attacks in Cologne aimed at scaring immigrants into leaving Germany. She turned herself into the police in November 2011 after being on the run with 2 other NSU members, Uwe Mundlos and Uwe Bernhard. The 2 men committed suicide after a failed bank robbery, and police later found weapons and far-right materials in their apartment. Schäpe burned the apartment and then admitted to being the person the police were looking for. During her trial, Schäpe claimed she wasn't an active member of the NSU, but only knew its members and disagreed with their actions. She apologized to the victims' families, saying she regretted not stopping the crimes, but many did not believe her. Prosecutors described her as manipulative manipulative, and said she worked to intimidate immigrants. In July 2018, Zszepa was found guilty of 10 murders, being part of a terrorist group, and arson. She was sentenced to life in prison without the chance of parole. Her appeal was denied in August 2021.
I don't understand why in a country like Germany files are destroyed and no one is held accountable. I don't understand why constitutional documents are not issued when one promises enlightenment. I'm disappointed.
The case sparked controversy in Germany, with some accusing authorities of overlooking far-right extremist crimes and systemic racism. Watch as the victim's family confronts this man in court, their anger turning the hearing into complete chaos. On May 16, 2022, in San Antonio, Victor Nathaniel Rivas attacked and fired at Ethan Sato several times as revenge for a theft that happened the day before. He was arrested, but later faced an angry confrontation in court when Ethan's family attacked him. It was a moment where the victim's family took matters into their own hands, showing him the consequences of his actions.
Jesus, we're going to have to talk. I tried to talk to you yesterday. We're going to set up another one, okay?
Victor Nathaniel Rivas remains in custody. Nathaniel Rowland was convicted of the 2019 murder of Samantha Josephson, a University of South Carolina, USC student. On the night of March 29, 2019, Josephson, after a night out with friends, ordered an Uber. She mistakenly entered Rowland's car, thinking it was her Uber ride. Rowland then locked the child-proof locks in his car, preventing Josephson from escaping. He drove her to a remote area, where she was tragically attacked with a sharp object 120 times. After Josephson was reported missing, her body was found by turkey hunters in Clarendon County. During a traffic stop, Rowland was arrested, and officers found evidence in his car, including an illegal substance, a rose gold iPhone, a keychain, and signs of blood. This evidence helped connect him to the crime. Rowland was charged with kidnapping, murder, and possessing a weapon during a violent crime. In 2021, Rowland was sentenced to life in prison.
Thank you. Madam Forelady, if you'll stand for me, please. Have you reached a verdict?
Yes, sir, we have.
Is it unanimous?
Yes, sir, it is.
Okay, if you will pass it up, please, and you may be seated. Defendant will rise. Madam Clerk, you may publish the verdicts.
Indictment number 2019 GS 40-2528, the state of South Carolina versus Nathaniel David Rowland. This is an indictment for possession of a weapon during the commission of a violent crime. Read the jury find the defendant guilty. This is signed four-person jury number 130, July 27, 2021. Indictment number 2019 GS 40-2450, the state of South Carolina versus Nathaniel David Rowland. This is an indictment for murder. Read the jury find the defendant guilty. This is signed four-person jury. This is signed by four-person jury number 130, July 27, 2021. Indictment number 2019 GS 40-2453, the state of South Carolina versus Nathaniel David Rowland. This is an indictment for kidnapping. Read the jury find the defendant guilty. This is signed four-person jury number 130, July 27, 2021. Madam four-person, are these your verdicts and the verdicts of the entire jury? Yes, ma'am.
Any individual polling requested?
Yes, Your Honor.
If you will poll the jurors individually by their juror numbers.
Yes, Your Honor. Juror number 130, were these your verdicts? Yes. Are they still your verdicts? Yes. Juror number 469, were these your verdicts?
Yes.
Are they still your verdicts?
Yes.
Juror number 169, were these your verdicts? Yes. Are they still your verdicts? Yes. Juror number 516, were these your verdicts? Yes. Are they still your verdicts? Yes. Juror number 635, were these your verdicts?
Yes.
Are they still your verdicts?
Yes.
Juror number 72, were these your verdicts?
Yes.
Are they still your verdicts?
Yes.
Juror number 534, were these your verdicts?
Yes.
Are they still your verdicts?
Yes.
Juror number 73, were these your verdicts?
Yes.
Are they still your verdicts?
Yes.
Juror number 201, were these your verdicts?
Yes.
Are they still your verdicts?
Yes.
Juror number 103, were these your verdicts?
Yes.
Are they still your verdicts?
Yes.
Juror number 520, were these your verdicts?
Yes.
Are they still your verdicts?
Yes.
Juror number 414, were these your verdicts?
Yes.
Are they still your verdicts?
Yes.
Jurors have been polled, Your Honor.
The verdict of the jury is unanimous.
He appealed the verdict, claiming that the evidence found during the traffic stop should not have been admitted in court. He argued there was no probable cause for the stop. However, the South Carolina Court of Appeals denied his appeal, stating that there was reasonable suspicion for the stop, especially since the car matched the description of the vehicle connected to Josephson's disappearance. The court emphasized that the overwhelming evidence of Rowland's guilt made any possible errors in admitting evidence harmless. As a result, Rowland's conviction and life sentence were upheld. Lance Bronco, a 23-year-old man, has been charged with first-degree murder in connection with the passing of 51-year-old Eric Leask. Bronco pleaded guilty to first-degree murder and felony aggravated battery using a dangerous weapon as part of a plea agreement. In exchange, the prosecution removed the death penalty as an option and dropped other charges, including felony robbery, burglary, unlawful possession of a firearm, and enhancements for using a dangerous weapon during the commission of a felony. Both the defense and prosecution agreed to recommend life in prison, with the defense arguing for a minimum of 25 years and the prosecution seeking a minimum of 35 years.
The best way to protect society, obviously, is incarceration, and you also understand that because you yourself agreed that at a minimum I should sentence you to a 25-year determinate period of time. So I take that as a recognition of what you've done and what should happen. With all of that being said, Mr. Bronco, it is the judgment of this court that you be sentenced to the custody of the State of Idaho Department of Corrections as follows. For count 1, murder 1, for a minimum determinate period of time of 35 years with an indeterminate period of time of life. For count 2, aggravated battery, that you be sentenced to a minimum determinate period of time of 10 years, followed by a 5-year indeterminate period of time. Those sentences will run concurrent. Will impose fines in count 1 of $10,000 and in count 2 of $3,000. You will pay court costs. You will order, there was a motion for restitution that was filed. The total amount of $73,858.84, with a request that it be left open for future medical expenses. We'll order that restitution in that amount with the proviso that it will be left open if there are additional restitution requests. If there are additional future restitution requests, Mr. Bronco, you will have the right to have a hearing on those. I won't just automatically impose them, but I will leave it open in case there are more out there. We'll issue a civil penalty of the amount of $5,000. With that, Mr. Bronco, I need to advise you, you have the right to appeal my decision. You have 42 days to file that appeal. If you think my decision is illegal or too harsh, you have the right to seek relief under Idaho Criminal Rule 35. You have 120 days to seek relief under that act. You can always seek relief under the Idaho Uniform Post-Conviction Relief Act. You have 1 year after your appellate rights expire to seek relief under that act. You have the right to have an attorney assist with all of those appeals, and if you cannot afford one would be appointed. You understand your appellate rights?
Yes, Your Honor.
Do you have any questions about what we did here today?
No, Your Honor.
Mr. Archibald, anything else in this matter?
No.
The murder occurred on March 9th when Bronco broke into a home in Idaho Falls, where he started fighting with the woman's son. Leask, the victim, attempted to intervene but was struck multiple times by Bronco, who was armed with a weapon. Bronco fled the scene after the incident, and Leask later succumbed to his injuries. The woman's son was also injured but survived. At the time of the incident, Bronco was already facing legal issues, including being on federal supervised release for previous felony convictions, and he had an active felony warrant. Get ready for a shocking revelation. Watch as we expose the terrible crimes committed by this suspect.
On April 3rd, 2023, to the crime of second-degree murder with intent not premeditated in violation of Minnesota Statute 609.19.
In September 2021, in Minnesota, Anthony Suggs tragically ended the lives of 4 of his friends. The suspect was sentenced after the judge heard arguments from both sides.
It is thereby the judgment of the court and the sentence of law that you be committed to the Commission of Correction of the state of Minnesota for a term of imprisonment of 326 months. That is minimum incarceration, 217 1/3 months. Maximized supervised release of 108 2/3 months. It is further ordered that you will be delivered immediately to the Commissioner of the Correction of the state of Minnesota. Against this, you will be given credit for 606 days. On this case, the court is also ordering restitution. I will reserve restitution for 90 days for the state to provide restitution information. Having been found guilty by a jury on April 3rd, 2003 to the crime of second-degree murder with intent not premeditated in violation of Minnesota Statute 609.19 subdivision 1, parens 1, as charged in count 2 of the complaint and standing convicted of that crime upon the verdict of the jury. The court hereby adjudicates and convicts you guilty of that offense and is therefore the judgment of the court and the sentence of the law that you be committed to the Commission of Correction of the state of Minnesota for a term of imprisonment of 306 months. That is minimum incarceration, 204 months, maximized supervised release of 102 months. That sentence will run consecutive to count 1 of the complaint of the conviction. It is further ordered that you will be delivered immediately to the Commissioner of Corrections of the state of Minnesota. You, throughout this trial and throughout this sentencing, cast blame on others. And this is a sentence in which you now have to take the responsibility for the acts that you have done. You cast blame on your father for the aftermath of what happened, and you testified you didn't remember something so significant. You cast blame on Jasmine and Matthew and Lois and Natasha for their, but make no mistakes, you caused their death. You pulled the triggers. You put them in their graves, and for that reason, you will serve this time.
On May 15, 2023, Judge Japal Harris sentenced him to 103 years in prison, with each sentence to be served one after the other. In September 2024, Cletter Barros was convicted of second-degree child cruelty in connection with the loss of his daughter, Sarah Barros, in Gwinnett County, Georgia. Prosecutors argued that Barros was aware of ongoing abuse by his wife, Natiela Barros, Sarah's stepmother, yet failed to intervene. Teachers from Harbins Elementary School testified that Sarah often came to class with visible injuries, which they reported out of concern for her safety. Despite this, Barros withdrew Sarah from school and left her in Natiela's care for homeschooling. On January 30th, 2024, Sarah passed away after allegedly being beaten with a wooden rolling pin by Natiela. Following 2 mistrials due to hung juries, Barros was found guilty in his 3rd trial. Judge George Hutchinson sentenced him to 10 years, with 8 years to serve in confinement and the remaining 2 on probation.
Sir, I've listened very carefully to the evidence that was presented through the course of the trial of this case. Whether this was tried 1 time or 3 times or as many times as was necessary to reach a verdict in this case is of no account one way or the other. The sentence that I'll impose reflects your behavior and the consequences of that behavior and the evidence that was produced during the trial of this case. Based on that, sir, I impose a sentence as follows. 10 years, the first 8 years to be served in confinement, the balance of the sentence to be served on probation. You will receive credit for the time you've served awaiting the disposition of your case. Once released to probation supervision, sir, there'll be no fine, but you will be responsible for paying a monthly probation supervision fee. Special condition of the probated portion of the sentence is that you shall have no contact whatsoever with the remaining siblings. So that we're clear, sir, no contact means no direct contact, no indirect contact, no contact through third parties or by any electronic means. Do you understand the sentence in your case, sir? A couple of other things I want to make sure that you're aware of, sir. You do have the right to appeal your conviction in this case. There are a couple of ways to do that. The main one is to file a motion for new trial. You could also potentially just simply file a notice of direct appeal to one of our appellate courts. In either event, I'm going to ask Ms. Drake to stay on with your representation, at least through the filing of one of those 2 motions. There is a deadline for that. You have to file that within 30 days of today's date. And once she has filed that on your behalf, what I'll do is appoint new counsel to represent you for appeal, as she cannot raise her own ineffectiveness during the course of any appeal that might be pursued in this case. The other thing that you should understand, sir, is that there is another avenue that you could use to pursue some sort of appellate relief in the form of a habeas corpus. There's a 4-year time limit on that. I'm not going to explain to you everything about habeas corpus. Your attorney can do that for you, but you do need to know that there's a 4-year time limit to pursue any sort of habeas relief. Sir, do you have a weapons carry license in the state of Georgia or anywhere else? All right, I'm going to ask the state to take possession of the evidence that was presented through the course of our proceedings and hold it safe for any appellate review that might come as a result of this conviction.
Yes, sir.
You may go with the deputy, sir. Good luck to you. And that concludes our proceedings in this case. Thank you all very much.
Thank you, Judge.
Lisa, would you hand that verdict form up to me, please?
Barros was also prohibited from contacting his surviving children during this period. Natiela Barros faces charges including murder and aggravated assault. Her trial is pending. This harrowing case of severe neglect and abuse by a parent led to the tragic loss of a child, exposing a deeply shocking and heartbreaking reality.
Somebody says perhaps at some point, maybe a neighbor came through a window and inflicted all those injuries and Gabby. That's not a reasonable doubt. That's not a doubt based on common sense and reason. And I would suggest to you, ladies and gentlemen, that if you brought your common sense, and I'm sure you did, to this courtroom today.
On January 1st, 2018, in Sumter Township, Brad Fields and Candace Diaz committed a horrific act against their daughter, Gabrielle Barrett, in their trailer home. They violently punished her for wetting herself, ultimately causing her tragic loss. The couple fled, but was eventually caught. The prosecutor described the heartbreaking case in a way that underscored the severity of their actions and the devastating loss of a young life.
It's official. Drag her into a cold bath. How hard was that day on Gabby? Each and every day was a struggle. Her only escape was school, and you will learn that even that was being taken away from her.
The victim's grandmother grew emotional while testifying, deeply affected by the tragic loss. Her tears reflected the heartbreak caused by the perpetrator's actions against an innocent child.
When the police took, but you're saying that you didn't see anything wrong with Gabby in terms of.
I don't believe that.
Is it?
Let's move on. Let's rephrase, please.
Did you see anything wrong with her with skin or physically wrong with her in the bathroom?
All I saw was red marks behind her calf on each leg and on her backside where her is.
And when did you notice that?
When I took over a CPR.
Was she laying on her stomach or her back?
She was on her back.
How did you see big red marks on her behind and so on?
And you could tell looking that there was red marks that came to the front towards the front of her stomach.
And were you able to identify what those red marks appear to be caused from?
They're causing speculation.
Well, were you able to identify what they look like?
Just what I told you. I didn't know what was going on. I didn't know what had happened.
Did anybody tell you what had happened?
I was told later.
That would be hearsay.
Sustained.
No,
Sustained without a better foundation.
Did the defendant tell you what had happened?
No.
Did your daughter tell you what had happened?
No.
Did you ask?
No.
Brad Fields was given a life sentence without the possibility of parole. Candace Diaz was sentenced to 30 to 60 years in prison. In this case, a man was held accountable for a series of violent crimes that deeply affected the victims and their families.
Now, this isn't to excuse what happened here, because what happened here is wrong. He understands what he did was wrong.
On November 4th, 2017, Dylann Dre Bonner assaulted two 18-year-old women and a 17-year-old girl in Cleveland. He also stole their purses, phones, and money before running away. In court, the prosecutor and defense attorney debated the details of the case and what punishment Bonner should receive.
A clear act of control and power. It's what you think of when you think of three women at an RTA station, in a secluded area of the RTA station, with a weapon. Yes, it turned out to be a BB gun, but the women didn't know it was a BB gun at the time. These were three young women, 17 and 18-year-olds old, that were just going to go out and live their life. They were going to go out and have fun with their friends. And they ran into this man. And to them and force your friends to watch you at gunpoint, to say, don't say anything or I'll blow your brains out. It's the power and the control that this man was exhibiting.
The only person he could, and that's what I was just going to get to when he said his family is frontline. Now, this isn't to excuse what happened here, because what happened here is wrong. He understands what he did was wrong, but it's a mentally ill person who was under the influence of PCP at the time, who doesn't remember what happened.
My heart goes out to the family. My prayers go out to the victims. I wish I could remember it, or I wish I would have knew what was going on. I wouldn't even been there. Only thing I remember is just going back to where I sleep at, outside St. Luke's building, because that's where I feel safe. And that's all I remember, Your Honor. I really am, I deeply am sorry.
Your Honor, I concede this defendant does have mental illness. I conceded that in my brief out, and that is certainly mitigation this court should look at. But it's not the type of mitigation that should allow this defendant to excuse his behavior. We have people in our community every day that suffer from exactly what he is suffering from, that don't commit these things.
The judge gave him the punishment he deserved for committing such an unforgivable crime.
Facts of this case are considerably disturbing to me, extremely disturbing. Of the three women who were 17 and 18 years old at the time, some of them, they were more than one time. The fact that they had to watch while their friends, the fact that you would one and then make another one perform oral on you. All those things are extremely troubling to this court because that each of these counts represent a separate action on your part. This court will run these counts consecutive for a total time of 55 years.
Dayon Dre Bonner was sentenced to 55 years in prison for his actions. On February 13, 2019, he admitted guilt to 5 counts of rape and 1 count of aggravated robbery. The court handed down a 55-year sentence for his crimes. At an age when most people are shaping their futures, defendants like this one destroyed lives, bringing a darkness that left the entire city in fear.
Ma'am, talk to me. Talk. No, ma'am. Talk to me. Talk to me. Well, you're going to have your opportunity to do that.
On June 23, 2019, in Anderson, a teenager named Stephen Powell fatally injured a girl named Janiyah Scott. When the case went to court, the proceedings were just as tense as the crime. As the city grew more upset over the girl's demise, the police shared details of the case with the media.
Last night, our Criminal Investigation Division went to Spartanburg, South Carolina regarding an alleged suspect in the death of Janiyah Scott. Would like to express our appreciation to the Spartanburg County Sheriff's Office and Chuck Wright for their assistance. They located a suspect, Stephen Braden Powell. We did transport him back to the PD last night for questioning. With our investigative sources, our leads, and questioning Mr. Powell, he was arrested last night and charged with 4 counts of attempted murder and murder in the death of Janiyah Scott. The bond hearing will be today at 2 o'clock in the Anderson Municipal Court. On the behalf of the city manager with me today, our mayor, the city council, we would like to thank all the officers for their time and due diligence that put into this case. Would also like to thank the Anderson County Sheriff's Office for their assistance in assisting us during this time of need. This time the investigation is going to continue. It's an active case. Further investigation is needed, and we can't comment enough about how much we appreciate the public reaching out to us through Crime Stoppers on this case. We do know there were 2 guns involved in this case, a pistol and a SKS rifle. So we know we have more than one suspect. We're still asking for the public to assist us by calling into Crime Stoppers. There is a $10,000 reward that's put out leading to the arrest and conviction of the person involved. And most definitely, the Scott family, we are still keeping them in our prayers.
When the defendant's bond appeal is heard in court, the judge's top priority is ensuring public safety, carefully considering it before deciding.
Mr. Powell, I'm going to give you some instructions, sir. I'm going to give all this to you verbally, and then I'm going to give you some instructions in writing so that you understand what needs to be done and what has to be done. I want everybody to stay cool. This is not a comfortable time for anybody in this courtroom, so I want everybody to be respectful. We're going to try to get through with this thing quickly and hope that everybody will be okay when this is over. Mr. Powell, you want to stand up here, or if you want to sit down, you're certainly welcome to. Mr. Powell, this is a bond hearing. It's not your court date. I'm going to give you some instructions, as I said earlier, so that you understand what your circumstances are. It's your requirement to be in court when your court date is. You have the right to a trial by jury. You have the right to a lawyer. I'm going to appoint a lawyer for you if you don't have your own lawyer. I'm going to ask you to understand that you need to be where you need to be when your court date is, if you're placed on bond. I'm going to read some charges to you and ask you please to listen. Who's got the warrants? Mr. Powell, sir, on the warrant number 2019-AO4207-00725, sir, you've been charged with attempted murder. On warrant number 00721, you've been charged on another charge of attempted murder. On charge number 00722, sir, you've been charged with another attempted murder. Those are concerning 3 different people who were present when this occurred. On warrant number 00727, sir, you were charged with possession of a weapon during a violent crime. On warrant number 00724, sir, you were charged with attempted murder. On warrant number 00726, sir, you were charged with murder. Y'all want to have a seat, or there's not enough seats? Okay. Want to say to you, thank you for being here. Want to thank everybody for being here. We'll get through this as quickly as we can. Is your mom here or anybody here? Just you here by yourself? Okay. Mr. Powell, on all the charges that I just read to you, I'm going to deny bond, which means you'll be here till your court date or till your lawyer makes application to have bond set.
The courtroom is filled with chatter about the judge's decision, but ultimately, the judge's authority and understanding of the law prevail.
Mr. Powell, you also have a right to a preliminary hearing. Preliminary hearing is where you ask the judge to review the evidence against you to see if the case goes forward. You only have 10 days to make this request. It will be my suggestion to you that you may choose to sign it today. Yes, sir. And then tell your lawyer that you've requested it. You and your lawyer can decide later on whether you want to have it or not. But if you don't sign it within 10 days, you cannot have it. Do you have any questions you want to ask me?
No, sir.
Okay. Do you have any questions from this side? Detective Vaughn, thank you for being here. Melissa, thank you. Thank you, sir.
I have a question.
Yes, ma'am.
Can you
Talk
get
to
in my
me.
face and
Talk.
tell me
No,
why?
ma'am. Talk to me. Talk to me.
I just want to know why.
Well, you're going to have your opportunity to do that. This is just a preliminary hearing, and you're going to be given some notice when you go to court. When there is the preliminary hearing, and you can ask those questions at that point, okay? Anything else from anybody?
The case is still in progress. What could drive someone to such inhumanity, amassing thousands of disturbing images of minors and destroying their own life in the process?
Only viewing the images and not touching a child does not go to mitigation for what you're charged with. You are only charged with viewing images. You're not charged with touching a child. So we're not going to compare what's the appropriate sentences to someone who actually molested a child.
In September 2019, Mike Davis was arrested in Columbus for downloading a large number of suspected images involving the exploitation of minors. Authorities discovered the disturbing content on his devices. In court, he was informed of the charges against him and the potential penalties he could face if convicted.
I am here on behalf of Michael Davis. When you're ready, I am prepared to make a statement. I think she knows what's going on.
Well, I don't know that we need any more facts than it's a pretty small complaint, so. Mr. Sherman.
Well, we're here on bond. I'm asking for a recognizance bond. He's been a part of this community for over 30 years. He's owned a home for over 30 years. He's never been arrested. He's been totally cooperative. I talked to the investigative detective yesterday. Production is not an issue in this case. It's going to be more than a month, but before they can even get this stuff to the forensics to be presented to the grand jury. So in this case, is going to be no bill for a future indictment. I am telling you that we have him under control. We are getting him counseling. We are working to try to right some of the things that have happened in this case. So again, I'm asking for recognizance.
Thank you, Honor. Given the nature of the instant charges and facts, state would be requesting an appropriate bond with the following conditions: no unsupervised contact with minors, no internet usage, and not to leave Franklin County. Thank you.
Agreed. I'm good with that.
I'm going to add another condition, which is that he turn over his passport.
Okay.
Because that would be Mike. He does According to Rule 46, you have to take into consideration all the factors with regards to bond. They include family and community ties, which he definitely has. He does not have any interaction with court. He has not shown up for court because he hasn't had any interaction with court. This crime did not include a weapon. He is not on probation, community control, parole, or anything like that. My only concern would be flight risk. And so I am going to set a $50,000 cash surety and a $50,000 cash surety appearance, just to make sure that Mr. Davis doesn't go anywhere in the pendency of this case.
Thank you, Your Honor.
Yeah,
I get that, but it's going to be dismissed for his future, and they're not going to present this grand jury during the pendency of this case. So what we're doing is we're going to make a bondsman rich. This case is going to go to forensics. I've had a number of these cases. It's going to be no bill. The last adult or child we waited 1.5 years for the indictment, and it was dismissed with no restrictions. I think that I'm just asking you. I don't see. How about if we I just don't see a cash or surety bond appropriate in this case because it serves no purpose. It's not going to. After it's dismissed for a future, the bondsman's off the hook. He's not going to do anything. He's just going to walk around with $5,000 in his pocket. To me, it doesn't. Why don't we make it a $50,000?
well, the problem is that if you do that, then there's nobody to chase him if he doesn't.
But they're going to dismiss it for a future. They're not going to have this case ready, man. I assure you.
The prosecutor outlined the potential consequences of the crimes, explaining that the offender could receive a lengthy prison sentence.
Yes, Your Honor. Mr. Davis was originally indicted with 4 counts of pandering-oriented matter involving a minor, 3 being felonies of the 2nd degree and 1 a felony of the 4th degree. It's the state's understanding Mr. Davis now wishes to withdraw his previously entered general plea of not guilty and plead guilty to the indictment. Counts 1, 2, and 3, pandering-oriented matter involving a minor in violation of 2907.322, felonies of the 2nd degree, and then count 4, pandering-oriented matter involving a minor in violation of 2907.322, a felony of the 4th degree. The parties have executed the electronic guilty plea form, indicating the defendant has been advised of his rights and wishes to waive those rights to enter his plea. That he's been advised of the potential maximum sentence. On counts 1 and 2, the maximum sentence is a definite sentence of up to 8 years. On count 3, the maximum sentence is an indefinite sentence, having a minimum term of 8 years and a maximum term of 12 years. And then on count 4, the maximum sentence is 18 months, for a total potential maximum indefinite sentence, having an aggregate minimum term of 25.5 years.
The judge asked the offender about the reasons behind his plea, seeking to understand his motivation and confirm that the plea deal was fair and appropriate.
When you change your plea to guilty, you also give up certain guaranteed constitutional rights. I need to make sure you know and understand these rights and what you are now waiving by pleading guilty. Do you understand that you're now waiving your right to have a jury trial with 12 people or a trial to myself as the judge, and either would determine whether your guilt was proven?
Yes, I do.
And you understand that you're now waiving your right to force the state to prove each element of each offense beyond a reasonable doubt? And do you understand that you're now giving up your right to present any defenses to the charges against you?
Yes, I do.
And you are waiving your right to have the court issue subpoenas to force people to come to court and testify on your behalf? And do you understand that you are now giving up your right to have your attorney cross-examine and confront any witnesses the state would bring to testify against you?
Yes.
And if you had a trial, you would have the right to testify on your own behalf, or you could remain silent, and your silence could not be held against you, but you are now waiving your right to testify at your own trial. Do you understand? And if you had a trial and were convicted, you could appeal certain issues to the Court of Appeals, but by pleading guilty, you're waiving most of your appeal rights. Do you understand? Do you have any questions about these trial rights you're now waiving? Do you freely and voluntarily waive these trial rights and choose to have the court accept your guilty plea today?
Yes, I do.
Now, the law requires that you understand the maximum penalties that can be imposed. Now, do you understand that in your case, there are 2 different structures of penalties that are available for the charges?
Yes, I do.
Okay. And you understand that in counts 1 and 2, the maximum definite sentence could be 8 years for each count. And are you aware that on count 3, the maximum sentence, well, there's a maximum sentencing range, which can range between 8 years and 12 years. Do you understand? And do you understand that on count 4, the maximum sentence could be 18 months? So the total potential maximum indefinite sentence could be from 25.5 years to 29.5 years. Do you understand that?
The case took a more serious turn as the judge detailed the offender's severe actions. After carefully reviewing all the facts, she announced the sentence.
Without using the standardized tools to check my blood pressure, a diagnosis means nothing. I want it to be clear, Dr. Abrams did what she was asked to do. I had probation reach out to her, ask additional questions after we received her report, and she did confirm everything I just said. Unfortunately, I can put no value in what she said because she did not assess you in a way that would be helpful to the court. I've reviewed the mental health records. And again, self-reporting of a lifetime of mental health issues doesn't help me and a simple example is, if you were a drug addict and you came before me and you told me, I went to 6 months of inpatient rehab, I've been clean for 12 months, I'm over this problem, yet you provided me no records, I would not be able to consider that in the proper sentencing because I don't have anything to see to show that this has been a lifetime problem. Counsel indicates that you are dedicated to making sure that your counseling will help you with preventing any type of reoffending. However, the records also indicate that you have indulged in alcohol and you have now developed an overeating habit. Each prescription you are on indicates that they have a warning that you should not consume alcohol whatsoever while you are taking the prescribed medication.
In May 2020, Mike Davis was sentenced to at least 4 years in prison after admitting to 4 counts of pandering sexually explicit material involving a minor. After his release, he must register as a Tier 2 sex offender for 25 years. When corrupted minds darken the world, innocence is lost, transforming a space meant for children's dreams into a nightmare, just as the defendant did.
So count 1 will be a 2-year fixed with an 8-year indeterminate. Count 2 would be a 0-year fixed with a 5-year indeterminate. These counts would run.
On May 18, 2023, John Jr. DeMaria IV was arrested in Ammond for knowingly possessing child exploitation images. The court is determined to deliver justice for this terrible crime. The defense counsel introduced evidence that could lead to a much harsher sentence, making the case even more challenging for the defendant.
My name's Jerry Lynn Taylor, Taylor.
And how are you employed?
I am a licensed professional counselor, therapist. My expertise is with addiction, so I'm also a advanced certified alcohol drug abuse counselor.
Okay, and where do you currently work?
Teton Counseling.
Okay. And how long have you worked for Teton Counseling?
I think 6 or 7 years, I'm not sure.
Okay, and did you do counseling prior to Teton Counseling?
Yeah, I worked for the Department of Corrections for 11 years.
What did you do for Department of Corrections?
I did their groups.
The prosecutor emphasized the accused's terrible actions, strongly arguing to the court that releasing him would pose a serious threat to society.
So today's case stemmed from a cyber tip that came into the ICAC unit back in May of 2022, and those cyber tips were coming into ICAC from May of 2022 through March of 2023. Synchronos is an electronic service provider that's associated typically with Verizon wireless users. So they typically provide the cloud account service for Verizon.
There was a phone number in Ammon, Idaho that was linked to the defendant. There were several CSAM images, which is child material, being uploaded to a specific Synchronos account that was associated with the defendant's number. Ultimately, there was a search warrant that was conducted on Mr. DeMaria's residence, and there were search and seizures of devices in Mr. DeMaria's possession, and within that, specifically his cell phone.
The criminal offered a remorseful apology, but it remains uncertain whether it will influence the court or if justice will take its course.
First and foremost, Your Honor, I wish to apologize to you, especially the community, to have to stand here before you. I do take responsibility. I've had a lot of things in my life spiral out of control. I developed a lot of codependencies that were unhealthy, where a lot of people would not understand that. No different than with alcoholics or individuals who use drugs. It's my drug, and it's been there throughout all my statements. It was my go-to. As my attorney stated, if I wouldn't have been arrested, I was pretty close to ending it. So I'm actually very thankful. And so far I'm thankful for my counselor, and it brought me closer back to my family. So I'm not a monster, Your Honor. I'm a guy that had problems and I didn't handle them correctly. I've reached out a few times. Unfortunately, the VA has dropped the ball quite a few times, and this isn't me shifting blame. I have tried to reach out for help in many different instances, and it wasn't there.
Before sentencing, the court reviews the defendant's crimes and hands down a thoughtfully determined punishment.
The addiction associated with it. I will follow the state's recommendation. Had they not modified their recommendation, I would have imposed the 3 fixed, but they see, like this court does independently, a number of good things, and as a result, I will impose a fixed sentence on count 1. As I recall, the counsel, was it counts 1 and 2 that were pled to, or were there other counts?
It looks like under the terms, just the 2, Your Honor. The rest
counts 1 and 2. So count 1 will be a 2-year fixed with an 8-year indeterminate. Count 2 would be a 0-year fixed with a 5-year indeterminate. These counts would run consecutive to one another, and so ultimately there would be a 2-year fixed followed by a 14-year indeterminate sentence. The court imposes a $1,000 fine on each of the 2 counts. Court costs and the Victims Relief Fund are standard, and there will be the reimbursement of the services of the public defender in the amount of $400.
On June 17, 2024, John Jr. DeMaria IV was sentenced to a total of 15 years in prison for 2 counts of willfully possessing child exploitative material. For the first count, he received a fixed 2-year term, followed by up to 8 years of indeterminate sentencing. For the second count, he was sentenced to up to 5 years indeterminate with no fixed term. These sentences will run consecutively. Upon release, DeMaria must register as a sex offender and pay court fees. On May 11, 2017, in Parma Heights, Cuyahoga County, Thomas Nuff planned and carried out a brutal attack, taking the lives of Regina Capobianco, 50, and her partner, John Mann, 65, in their home. After a detailed investigation, the police arrested Thomas for the crime.
I've offered already to Regina and John's family that I am sorry for how things turned out, and when you show emotion and you say you're sorry, they say you're lying. When you don't, you're a psychopath. So it's like a lose-lose situation, and I understand that they need somebody to hate, but This isn't over, and I'm gonna pursue every avenue to get the truth out. Everybody with the Parma Heights Police Force and the prosecutors that lied and put people on the stand that lied, everybody's gonna have to answer to it. I'll man up and take responsibility for everything I've ever done. And, I respect the court and the jury's decision and the evidence that they had to work with. But, it's not over, and I don't mean that by any disrespect at all to Regina and John's family, but just the fact that, it's something that I need to do.
Is a criminal bold enough to listen to a child whose father has been taken from him, no matter how serious their own crimes are?
Given the process being unexpected, I'm going to try and be brief before I read my statement. Your Honor, I wanted to thank you specifically. I wanted to thank the prosecution team, Anna Feralia. I wanted to thank Captain Steve Scharschmidt of the Parma Heights Police Department and all of the police officers that helped investigate this case. Your tireless work to seek justice has given me a level of comfort that my gratitude and my ability to express will ever be sufficient. Thank you. I did not plan to speak to you, Thomas, but I am going to speak to you given what you have just said. When we make mistakes in life, we need to take ownership for those mistakes. You have sat here for 8 weeks of a trial, and for me, for being here for the first time, hearing you not admit to what you have done is sickening and grotesque. Your life is not over. You are breathing air, and you are on borrowed time. My dad is dead. Regina is dead. Their lives are over. The only thing that I wish to say to you, because I wish to say very little to you, is you have an opportunity for the rest of your life to do something. Make it count. My dad was a goofy, bright and sensitive man. He loved the Cleveland Browns, watching MASH reruns, and doing community theater. He had a full scholarship offer from Heidelberg University in astrophysics. He ended up floating into electrical contracting from his interest in solar power. He loved the idea of cheap renewable energy. He even studied to be an architect because he thought it would help him develop solar power cells. Later in life, he became a computer programmer. He truly had a gifted mind and could do just about whatever he wanted to if properly motivated. People tended to like my dad. He had a gregarious and colorful personality with an oddball sense of humor. He had his issues too. Being bipolar had a significant impact on his life, and often he'd be his own worst enemy. His illness led him to questionable decisions in people. Insecurity and sadness plagued him, and in the end, I think it led him to people like...
Is the child close to giving up because of the complicated legal steps before the execution, the only way to find closure after their father's tragic loss?
Did his parents not love and care for him enough? Did he not have friends or mentors in his life to help set him on a better path? Did he not have accessible resources to educate and improve his station in life? Is it possible that this lack of resources, caring people around him, and prospects led him to crime at a young age?
After reviewing all the facts and evidence, the jury gives their verdict. Sometimes, the crime is so serious that the judge has no other factors to consider. In these cases, the judge agrees with the jury and hands down the sentence.
After considering all the required factors under 29, 11, 12, and 13, and then 29, 29, 03, and 04, I am sentencing the defendant as it relates to count 2, the aggravated murder of Regina Capobianco, to death. Again, I find that the aggravating circumstances outweigh the mitigating factors. Again, moving on to count 4, the aggravated murder of John Mann, I sentence the defendant to death. I find that the aggravating circumstances outweigh the mitigating factors. Additionally, count 5, aggravated burglary, I sentence the defendant to 11 years. There is a repeat violent offender specification attached to that count. Consecutive sentences are not disproportionate to the seriousness of this offender's conduct. The The consecutive sentences are not disproportionate to the danger that this offender poses to the public. Mr. Knuff committed one or more of the multiple offenses while he was under post-release control for a prior offense. Mr. Knuff committed at least two of the multiple offenses as part of one or more courses of conduct, and the harm that was caused by the two or more multiple offenses was so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct adequately reflects the seriousness of Thomas Knuff's conduct.
The jury convicted him of aggravated murder, kidnapping, and other charges. The trial judge, Dina Calabrese, sentenced him to death, saying she had hardly seen someone with so little remorse as you. In March 2024, the Ohio Supreme Court upheld the death penalty, dismissing 24 legal arguments made by Knuff, including claims of self-defense and lack of evidence. On August 26, 2020, in Melrose, Massachusetts, Mark Wilson took the lives of two boys at their home. When the bodies were found, the police determined that Mark was responsible for the crime and decided to charge him. Eventually, everything someone does is uncovered, and in this case, the prosecution showed the jury everything Mark had done to the victims.
Sarah Baker, a married mother of three, lie asleep in her brand new home. A house that her and her husband, Chad Baker, had purchased and moved into just 10 days before. The Bakers had moved to Putnam County because they had a lot of family here. Sarah's dad, his wife, their kids lived just around the corner from this new home. Sarah's sister, Cindy, lived in this area. And so they moved up here after living in South Florida for a number of years and raising their boys to be closer to family. Chad was an over-the-road trucker, and so on the morning of August 26th, he was gone. He was out of town working. And so Sarah was asleep that morning in the back of her house in her master bedroom with her 4-year-old child who was sleeping with her. Tayton was her 14-year-old, and Robert was her 12-year-old son. And they weren't asleep in their bedrooms that particular night before, and it was because they had just moved into this house. They hadn't had Wi-Fi and internet hooked up yet, and as teenagers, they were tied to those phones. And so both boys had kind of found the perfect spot in the house where they could get their cellular service, and they were kind of always in that spot, and they fell asleep in that spot using their phones. So they were sleeping out in the main part of.
People often use different methods to show they're innocent. To prove Mark Wilson's innocence in this case, his lawyer used several strategies.
Mark was excited about this. But of course, as with any relationship, everything's not always rainbows and butterflies. There were some hard times that they fell on here and there. And so during those hard times, they would have to live in different places. One of those places, a lot of the times, they would live with Cindy's sister Sarah. Here and there from here on out, and of course that included Sarah's children and her husband. So their family dynamic was just a little different. It wasn't just the three of them. They would have to get help from people here and there, mostly Cindy's sister. He would always provide for his family when he could. He would, when he wasn't working, making sure he was strengthening their bond. Cindy didn't have a driver's license, so he did all the driving for the family, just making sure that they could spend whatever time together that they could. I can't even imagine to try to live life without you and her. Again, words from Mark's own letter. He had such a love for his daughter. Mark loved his daughter more than anything. And because he loved her so much, sometimes that caused him to have to make some selfless decisions. Again, like I said, they fell on hard times here and there. So within that time frame that they would have to do that, he would have to move back in with a different person, meaning Sarah and her family here and there. So back in August 2020, the Minnie family, meaning Mark and Cindy and baby Caitlin, they had their own place, but the electricity was turned off, they had no water. So at this point, he said, well, Sarah's made an offer of her to us to move in with her, so we'll make that decision to do so. Also, during that time frame, he discovered that Cindy was pregnant. They were expecting their second child.
It is common practice for the judge to announce the jury's verdict on the punishment of a suspect in court. In this case, the judge did just that.
The jury found that beyond a reasonable doubt, the court agrees and affords the factor great weight. The third factor the state presented was that the first-degree murder was committed in a cold, calculated, and premeditated manner, without any pretense of moral and legal justification. The defendant's argument on this factor centers on a question from the jury at the close of the case on the merits. Specifically, the defendant attacks the heightened premeditation necessary to find this factor and cites to the jury's question. The jury asked a question during deliberations that suggested that some of the jurors were considering finding premeditation as the basis for first-degree murder, while others found felony murder as its basis. In the merits phase, the jury may find an individual guilty of first-degree murder under a theory of either felony murder or premeditated murder. No special verdict is required. He took the time in the middle of the murders to change weapons to make sure the victims were dead. Finally, the court concludes there wasn't even the slightest pretense of moral justification. Robert was asleep and defenseless. Tayton was awake, but as he sought to escape and perhaps call for help. Neither of these boys did anything to the defendant to justify the crime. The court finds this factor proven beyond the exclusion of a reasonable doubt and affords it great weight.
When deciding a suspect's fate, a judge always takes into account whether the sentence fits the crime and is fair to the victim. This case was no exception.
Conclusion and sentence. The defendant committed two truly horrific murders of innocent children. Tayton's death in particular was especially cruel and undoubtedly painful. On count one of the indictment regarding the death of Robert Baker, the court finds that all three aggravating factors proven beyond it to the exclusion of a reasonable doubt. The court finds the factors are proven are sufficient to impose a sentence of death. The court finds the defendant is eligible for the death sentence on this count. On count two of the indictment regarding the death of Tayton Baker, the court finds all four aggravating factors proven beyond to the exclusion of a reasonable doubt. The finding on heinous, atrocious, and cruel by itself is sufficient to find for death. The court finds that in the aggregate, the four factors are sufficient to impose a sentence of death, and that the defendant is eligible for a death sentence on this count. The court has independently analyzed each of the mitigating circumstances and found many to be proven. The court has above assigned a weight to each of those circumstances. While they are expressed together, each of the circumstances are proven as to each of the two counts as if analyzed independently regarding Robert Baker and Tayton Baker's murders. There is no evidence suggesting any more or less weight should be applied on any of the circumstances with regard to either of the two victims. The court has deliberated carefully on each circumstance proven and given it appropriate weight as stated. Having made all these conclusions, the court is still permitted by the language of the statute to impose a sentence of either life in prison without the possibility of parole or the death penalty. The defendant asks this court to disregard the verdict and override it in favor of life. This is not the case for such action. The court finds that the jury's report of its weighing of the aggravating factors and mitigating circumstances substantiated by competent evidence. The court finds insufficient basis to override or disagree with the jury's recommendations, finding that the prerequisites of law have been met and that a jury of his peers has unanimously found death to be the appropriate sentence. Counts 1 and 2 are to run consecutive to the sentence on count 4. On count 4, the court enters a judgment of guilty on the verdict and sentences you to life in prison. All standard court costs and fees are imposed. The discretionary fees, as previously discussed, will be imposed. The clerk will prepare a final judgment and sentence. The defendant is advised he has an automatic right of appeal to the Supreme Court of the state. The defendant is entitled to representation in that appeal. If you cannot afford an attorney, one will be provided for you at no charge on application to this court. May God have mercy on your soul. We're adjourned.
On January 27, 2023, Judge Howard McGillen sentenced Mark to death. The case stood out due to its extreme violence and the following legal process. Every relationship has problems, but some problems become violent. Unfortunately, our next case falls into this category.
Can you please tell the jury how and when you met them?
Well, I actually met the kids first through Joseph. I have my niece.
In 2017, in Jacksonville, Chad Absher ended the life of his ex-girlfriend. It was the officer's job to question the suspect and figure out what happened that day.
Oh, paying my taxes and everything.
From the business
Yes,
standpoint?
yes, ma'am.
And have you previously been convicted of a felony crime?
Yes, ma'am, I have.
How many times?
2 times.
You've heard all the evidence about Ashley Rucker and Lisa Rucker sitting here this week, correct?
Yes, ma'am, I have.
Can you please tell the jury how and when you met them?
Well, I actually met the kid first, little Joseph. I had my niece. I was done working one day. I was out. When I get done working in the evenings, I clean up my trailer and get my equipment ready for the next day to work. And while I'm doing that, I have my niece driving more around in the yard. She just like a rabbit. And he came running up and he was hiding in the bushes. And I seen him and I was like, hey man, I showed him how to ride the other one. So I had them out there and that's how I met him. And then the sisters came after the fact because that was their grandma's house while they was across the street from where I was.
Okay, so they lived close to you at the time?
No ma'am, the grandma was across the street. So they seen their grandma.
Understood. Okay, so did you eventually form a relationship with Ashley Rucker?
Yes ma'am, I did.
And did you live together at times?
We have 4 or 5 houses.
And did your son Joseph live with you as well?
Yes ma'am.
Did you love Ashley?
Yes ma'am, I did.
Did you think she loved you?
I believe so.
When someone is taken away from a loved one, it leaves a deep wound that takes a long time to heal.
You know, depending on the situation.
Would you be broken up in all likelihood?
There were times, yes ma'am.
And what was your relationship with your son Joseph like?
I thought it was great.
Did you love him?
Of course I did, like he was mine.
Was Joseph's father in the picture much at the time?
No ma'am.
So did you take that kind of role with him, or what kind of relationship formed with Joseph as a result of that?
I'm sorry. You said.
And that's a long, convoluted question. I'm sorry. So, what kind of relationship did you form with Joseph?
You know, I try to teach him how to drive everything that I try to take him fishing.
And so Joseph was included in a lot of the things that you did?
Yes, ma'am. Anything he was interested in.
And so he was also included in a lot of things you and Ashley did together?
Of course.
So what was your relationship with Lisa Rucker?
Lisa was, here's what it was. She came along with the sister. Sometimes she had problems.
Did she live with you?
Yes, ma'am. Sometimes in a few places.
So did she live with you and Ashley at all the places, or just some of them?
Not just a few. She would stay. And then, she'd get another boyfriend or something.
When Lisa Rucker did live with you and Ashley, did her son Colton live with you as well?
Yes, ma'am, I did.
And did you have a similar relationship with Colton that you did with Joseph?
I did.
So, I want to move to the day of the incident. The shooting involved in this case took place in the early morning hours of October 31st. And on that day, you were living with Lisa, Ashley, and her sons, correct?
Yeah, I wouldn't stay there. I stayed there at night time.
So you were not living there. Correct me, please.
Yeah, I just stayed there at nights, ma'am.
Okay. Why were you not living there at the time?
It was just best for us the way we had it worked out.
So where were you living?
I had another place.
Everyone eventually has to face the consequences of their actions. Chad learned the outcome of his actions too.
But no sentence I impose today is ever going to bring her back, or will ever, I suspect, satisfy anybody. But I will impose the sentence I think is appropriate and that is within the bounds of the law. So with that, Mr. Absher, as to counts 1 through 3, the jury having found you guilty on each of counts 1 and 2, and you having pled guilty, a plea I accepted. As to count 3, I'm now going to adjudicate you guilty of each of those 3 counts. On count 1, I will sentence you, as the law requires me to mandatory life in prison with no possibility of parole. On count 2, I'm going to sentence you to life in prison. As required, well, not as required, but I feel as appropriate in this matter. As to count 3, I will sentence you to 15 years in prison with the required 3-year minimum mandatory. You will get credit for the 1,855 days that you have already served. Count 3 will run concurrent to count 1 and 2, but count 1 and 2 will run consecutively with each other. That is, count 1, then count 2, and count 3 will run concurrent to count 2, or 1, regardless. I will impose mandatory felony court costs of $518. There's a $150 attorney fee lien. Is there any restitution that I must order, or do I need to reserve jurisdiction?
I would ask you to reserve jurisdiction, Your Honor, and I think just also for record purposes for count 1, would that include also the mandatory life and the 10-20 life?
10-20 life, both on count 1 and on count 2.
Oh, okay, yes,
so the jury found that the defendant actually possessed and discharged a firearm with great bodily harm.
Thank you, Your Honor.
So those minimum mandatories are applicable based on the jury's findings. I believe that is all. Do you understand your sentences?
Yes, ma'am.
Now, you do maintain the right to appeal. Of course, both the judgments and the sentences. You must do so by filing a notice of appeal within the time so designated to the clerk of court. Would you like an attorney appointed to represent you on appeal?
Yes, ma'am.
All right, then at this time I'll appoint an attorney for purposes of appeal. And that, sir, will conclude this matter today.
On December 1st, 2022, Absher was given a life sentence without the chance of parole for the first-degree murder of Ashley Rucker. He also received an additional life sentence for the attempted first-degree murder of Lisa Rucker, along with a 15-year sentence for being a convicted felon in possession of a firearm. We've seen our fair share of entitled people, but this one takes it to a whole new level. For some quick context, she's been divorced for 2 years and has already received plenty of support since the divorce, as we'll hear. But today, she's back in court, asking for even more money, which seems to be happening a lot lately. However, things don't go as planned, as we'll see.
Brought this case before the court. What's going on?
Well, I'm divorced from the person that didn't show up.
I see that.
Yes, and I'm here to ask the court for more spousal support. I went part-time on my job. I'm no longer working full-time. I've lost money. And the man's done nothing but cause me trouble since we've been divorced. He does all kinds of crazy stuff.
Okay.
And I deserve more money with all this harassment. Plus, I want a restraining order against him. This has to stop. My nerves are on edge. Can't take much more of it. But I think $100 a week extra for spousal support would be fair with all the, the headaches he's given me and everything like that.
You think it'll be fair?
Yes, I've left him alone. I don't go around him. It's him doing the harassing.
Okay. So let's talk about that. You said you believe $100, an extra $100 a week is fair.
Yes.
Why do you believe that's fair?
Well, like I said, my wages have went down. I'm only working part-time now. We're doing layoffs and things like that. So
you said your wages?
Yeah, my wages.
Okay.
Are going down, and his are going up because he still gets those 2 raises every year. He's been with that company forever. And he makes good money. I don't make half of what he's making. And it's been really tough.
You've been divorced for 2 years now. He's not your husband anymore, so why would it make sense for him to give you more money just because you're making less? That's your problem. Honestly, I'm a bit confused as to how this woman thought she'd have a strong case. She even took it to court for an extra $100 a week, which she could easily make in one shift at a near minimum wage job. Maybe she should focus on that instead of trying to get more money from her ex-husband. It's almost a joke. Her ex didn't even bother showing up, which says a lot. And if she's really being harassed, this isn't the place for it. She should contact the police, not the support court. For someone who seems to hate her ex so much that she wants a restraining order, she sure seems very interested in his wallet.
I think I deserve that extra $100 a week, and he can certainly afford it.
What does he do for a living?
He's a CEO for an oil company.
Okay.
Makes really good money, bonuses and all that stuff. I mean, he's just raking it in.
How much is your spousal maintenance right now?
The spousal maintenance, it's about $325 a week, maybe.
Okay. So I guess I'm confused as to why you're here, because you haven't said anything that will warrant an increase in your maintenance.
Well, I went down on hours from work. I mean, that's a financial burden.
Well, so you went down on
my
hours.
boss did. My boss did. I didn't do it. My boss made me take less hours.
Again, how does making less money have anything to do with getting more from your ex-husband? If you get divorced and your income drops for whatever reason, that's your problem. Get a second job, cut back on expenses, but don't go to court asking for an extra $100 a week. This behavior is lazy and parasitic. The entitlement here is unbelievable. Keep in mind, they've been divorced for 2 years now, which is plenty of time to get your life and finances in order and become financially independent instead of dragging your ex back to court. This whole case has gotten so ridiculous, it's almost laughable.
But nothing has really changed with a lot of your expenses. You said you don't have a car note. You have a little bit left on your home to pay off. Sounds like you're mainly paying utilities and then a mortgage.
And the insurance for the car, I mean, the insurance is always expensive. Gasoline prices always going up.
Right, but you had those expenses at the time that you were divorced, correct?
Yes.
When you all were divorced, did he have a 401k in existence? And this is Texas, which is a community property state. So I'm assuming you at least got 50% of that.
Yes, I did, but
yes,
I don't think that should be taken into consideration.
No, ma'am. It was taken into consideration the first time you received spousal maintenance. You can't have me take it into consideration again. That's not fair, and it's definitely not the law.
You know, my age, I'm not going to find much now. I have to stay where I'm at. I feel like I'm trapped in this life.
And Ms. Ellison, I feel like you came here to waste my time because I cannot give you an increase in spousal maintenance just because you're asking for it. No, ma'am.
25?
Even $5. The answer is no. So is there anything else that you needed from me here today? Because I cannot grant you spousal maintenance just because he's made an increase from his wages.
Well,
if that were the standard, then everyone would come in court asking for an increase.
Well, people need increases. I mean,
well,
women living on their own, I mean, that's hard.
Let me ask you this question. When you all were divorced and you received half of his 401k, how much was that?
That was a nice piece.
Okay, what's a nice piece? Give me a number.
About $250,000.
Okay, well, you know what? If there's nothing further, your case is dismissed and so are you. Thank you.
Let me get this straight. Not only did this person get the house, have her car paid off, and receive weekly spousal support, but she also got $250,000 on top of all that. The nerve to ask for spousal support after getting $250K, that could have been her retirement fund. What really confuses me is how she makes it sound like she's struggling with bills, like still paying off the house and car insurance. So my question is, where did the $250K go? Did it just disappear? Was it spent? Because if so, she somehow managed to blow $250K in just 2 years. Maybe she spent it on constant trips to the salon, or who knows what else. What I do know is this is one of the biggest jokes I've ever seen. I'm at a loss for words. Let me know what you think in the comments. This case tells a story of betrayal, where one man's actions have deeply affected his family's life.
It says that I was a small engine mechanic, but I was actually a heavy engine mechanic, a diesel engine mechanic. So there was a misunderstanding during the interview.
From 2010 to 2019, Craig Lawrence abused his 2 young daughters in their home in Copos, Michigan. The girls, now 21 and 14, testified that their father started grooming them at a young age, leading to multiple assaults over the years, which they described as unbearable. In court, Craig's lawyer argued that some of his actions should not be seen as predatory behavior.
Cass County Victim Assistance impact statement that was filed by Scale. I had an opportunity to review all those documents. So let me just confirm with counsel if they had an opportunity to review those documents and if they have any additions or corrections.
None of the people have had that opportunity. We have no additions or corrections.
All right. And
likewise, Your Honor, I've had an opportunity to go over the pre-sentence investigation, the letter from Ms. Scala. I had an opportunity to go to the jail and go over the same documents. I provided Mr. Lawrence a copy of the sentencing manual yesterday so that he could understand better the offense variables and PRVs. And I do have some objections to the scoring of the offense variables.
obviously, there's no prior record,
Correct.
misdemeanor felony record, although PRV 7 has scored no objection to that.
No objection to the PRV.
All right, we'll hear then the objections to the offense variables.
Your Honor, I think that offense variable 10 being scored at 15 is incorrect. When it comes to the agent's description of the touching and penetrating, that's part and parcel of the sentencing offense, and I don't believe that that should be counted towards predatory conduct. Predatory conduct is post-offense conduct. The remainder of what the agent described is all pre-offense conduct. I do not believe that that counts as predatory conduct under OB 10. In the manual, it has a definition of predatory conduct, and it states that the predatory conduct is post and pre-offense conduct. But again, the pre-offense conduct is all part and parcel of the sentencing effects, and I don't think it should be properly scored at 15.
Is your position that should be scored at 10 because it is the abuse or domestic relationship?
Correct, Your Honor. I think the 10 would be more appropriate scoring.
Prosecutor Fitz, any position regarding the scoring of the OB 10?
Judge, I think it's properly scored. There certainly was, obviously is the primary convictions for this defendant on multiple counts. We have a number of instances of predatory grooming behavior, predatory behavior that included with Madeline at age 5 and 6, going into the bathroom, watching her take a bath, staring at her in a disturbing fashion. Then later on, touching her, at age 7 and 8, and all those things led up to the ultimate criminal offense of at age 9 of beginning to penetrate her. Also, you have grooming and predatory behavior by him having the girls watch, at least Serena watching those type of things.
The defense raised other points, arguing that some charges didn't have enough evidence and that actions after the offense were not connected to the crimes being sentenced. However, the prosecutor disagreed with this argument.
Yes, Your Honor. And OB 13, I think, is improperly scored at 50 points. I don't believe that there's a preponderance of evidence of the number of instances. The testimony at trial certainly led to conviction on, in this case, over 20 of the counts, but there was not all the counts did the jury find Mr. Lawrence guilty of. And there still needs to be a preponderance of evidence to show that the other events happened, and I don't think that just the mere reporting of other instances is a preponderance of evidence given the testimony at trial, so I don't believe that OB 13 is properly scored at 50.
Judge, again, the jury believed both of these victims in this matter, and the testimony was clear for one of them that the penetrations were over 100 in number, and the jury obviously in the situation found these young women believable. The court also had a chance to hear their testimony and judge their credibility, and I think that they certainly established by preponderance of the evidence that this occurred around 100 times or more.
I think having heard the testimony, I think the court can't preponderate under OB 13 that there were involved in this situation within a 5-year period, which is required under OB 13, that there were at least 3 or more penetrations against a person or persons less than 13 years of age. And I believe that the scoring will be 13 at 50 points is proper. So I'll note your objection, Attorney Gregg, for the record, but we'll go ahead from the court standpoint, leave OB 13 score at 50.
Thank you, Your Honor. My last objection is to OB 19. The conduct that they're using to score OB 19 at 25 points is not related to the sentencing offense at all. And although Walker certainly allows the court to consider post-offense conduct, there still has to be some sort of connection to the sentencing effect. There are charges pending for this conduct, and I think that it would be a different situation if he had tried to escape, or if he had, fought with the guards being transported back and forth, because those have some tie to the sentencing offense. But this conduct alone, according to the agent and according to the allegations, started in a dispute between another inmate and Mr. Lawrence that bubbled over into dispute, but it has no connecting tissue to the sentencing effect. And I do think that all of the offense variables need to have some of that connective tissue, whether it's post-offense conduct or not. So I think that OB-19 should be properly scored at 0, because with the exception of this conduct here that's described, he did not try to flee. He did not, resist arrest. He did not even leave his home, even though he had months between the time the allegations were first made aware to him and the time of his arrest. So I hear what the court is saying, but I would just say that my position on that is that it was a mere denial. The follow-up question of why would they do it provokes a response that, is speculation on Mr. Lawrence's behalf. But it didn't interfere with the investigation. It didn't interfere with the administration of justice. And so I still think that even with that, it would be properly scored at 0.
Craig argued that the case was made up. However, the prosecutor stressed the seriousness of Craig's actions and praised the courage of the victims who testified.
None, Your Honor. All right. Mr. Lawrence, Attorney Gregg indicated that he got you a copy of the report and you had a chance to review it. Is that correct?
Yes.
Okay. I'm going to give you an opportunity to address the court if you choose to help you on your own behalf. You don't have to, but you'll have that opportunity. In reference to the information in the report, were there any fact discrepancies you had? Obviously, children, education. When we look at all the background information, were there any additions or corrections that you want to make to the report?
Yeah, the report stated that the interviewer said that I had 3 daughters, but I have 2 daughters and 1 son.
Okay. So
let's state that.
All right, we'll go ahead and make that correction and note that you have 2 daughters and 1 son as opposed to 3 daughters. With that, then, anything else you wanted to, before I give you the opportunity to allocate, any other corrections?
Yeah, there was misinformation about my work history.
Okay.
About statements that I made.
Okay, and the statements I understand. What about your work history?
It says that I was a small engine mechanic, but I was actually a heavy engine mechanic, a diesel engine mechanic. So there was a misunderstanding during the interview.
So when it says small engine repair, you would say that?
I was previously a small engine repair, but currently my latest employment was a diesel engine technician.
And would that have been with Osra?
Osra Kubota.
Okay.
The defendant told the victim, this particular victim, as well as the other victim, that if you tell other people, if you tell your mother about this, you're gonna get in trouble. And again, the threats were also made regarding the mother. The court also knows that in regard to the other victim, as we talked about before, that he groomed her, again, at a very young age, from age 5 and 6, as she testified and as acknowledged and as indicated, that he would come in while she's taking a bath and stare at her in a disturbing fashion. Certainly, I think as the facts would support, as he was, satiating with the fact that he was going to also this young girl. He started it, the actual at ages 7 and 8, touching her repeatedly, and then at 9, full blown. Also, with this young victim, When she was sick, that was one of the times that he utilized the opportunity. And again, this is extremely disturbing behavior. Again, so focused on his own perverse gratification that he would molest young girls even when they were sick.
The court recognizes the harm caused by the offenses and Lawrence's manipulative behavior in controlling and abusing the victims for a long period of time.
All right, well, Mr. Lawrence, I was here before the court here today for sentencing, and following a conviction by a jury on November 22nd of last year, your daughter, Serena Madeline, which with acts that included oral, visual penetration, touching of the box. With Serena, these acts, according to her, occurred over 100 times between approximately 2010 and 2017. With Madeline, as she was younger, the abuse alleged to occurred. Some started somewhere around 2014 and continued through 2021. As a result of your actions, reported Madeline was in therapy, has repeatedly cut herself, and Serena has also been in counseling for well over the last few years herself. So, Mr. Lawrence, I know you claim that this was all some big scheme by your wife because she somehow wanted to get her hands on your children's creepcaught money. But to me, it's unbelievable that your two daughters would come into this courtroom and testify the way they did against you if you were the type of father that you would like us all to believe that you are. Your daughter's testimony in court's opinion was not only credible, but I saw nothing from either of them to lead me to believe it was concocted in any way. But we're not here to debate that issue here today. The jury heard the testimony, they heard your position, and the jury convicted you of the charges that you've been sentenced here today on. And so accordingly, what the court is going to do, as Attorney Drake indicated, the court has recalculated your guidelines. Again, with the recalculation, those guidelines would even be below Attorney Drake for 25-year minimum. And I think even as originally calculated, they were still below the 25-year minimum. So what I'm going to do in this matter, Mr. Lawrence, on the counts of 1 through 8 charges of criminal conduct first degree in file 22-10325 FC, will be the sentence court will be committed to the Michigan Department of Corrections to serve a term of incarceration in state's prison for not less than 25 years to a maximum term not to exceed 40 years, with credit for 492 days already served. In addition, in that matter, you'll pay $68 in minimum state costs on each count. Court costs of $500, court being reasonable based on the average cost of prosecuting the case here in the county. We're going to order you to pay a crime victim rights assessment in that file of $130. Court will also order you to pay attorney fees in the amount of $350 to partially reimburse the cost of providing legal assistance in this matter. You'll also be sentenced to lifetime electronic monitoring as required by statute. AIDS and STD testing complies with the DNA testing, pay the associated $60 fee. On the counts 9 through 11 in that file, criminal conduct in the second degree, it will be assessed to court you committed to the Michigan Department of Corrections to serve a term of incarceration in the state's prisons of not less than 2 years to a maximum not to exceed 15 years with credit for 492 days already served. In addition, you'll pay $68 in minimum state costs on each count. As further required in those charges, you'll be required to be placed on lifetime electronic monitoring as well upon your release from incarceration. In file 22-10326 FC on count 1 charge of criminal conduct in the first degree, will be sentenced court to committed to Michigan Department of Corrections to serve a term of incarceration in state prison for a term not less than 25 years to a maximum term not to exceed 40 years with credit for 492 days already served. In addition, you shall pay $68 in minimum state costs on that count and a crime victim rights assessment of $130. And again, as required by statute, you shall be sentenced to lifetime electronic monitoring required by law and comply with any AIDS, STD testing, and comply with DNA testing. In that file, on counts 2 through 5 of criminal sexual conduct in the second degree, the sentence court you obtained in Michigan Department of Corrections to serve a term of incarceration in state's prison of not less than 2 years to a maximum term not to exceed 15 years with credit for 492 days already served. In addition, on those counts, you'll pay $68 in minimum state costs on each count. And again, on those matters, you will also be placed on lifetime electronic monitoring upon your release from incarceration. You shall also comply with DNA testing. There was no restitution requested in this matter by the prosecutor's office, so none is ordered at this time. Sentences in both files will run concurrently with each other. Mr. Lawrence, I will advise you do have the right to appeal your sentence or conviction. Here today, I'm going to have the bailiff deputy here provide you with appellate right to review. If you do wish to file an application for leave to appeal, you can do so. And if you're financially able to retain an attorney and wanted to have an attorney appointed to represent you in this matter, fill out one of those forms. You'll receive 2 copies of that form. Return one of those copies to the court completely filled out. The court will review that. If you do qualify for the appointment of counsel at public expense, the court will appoint counsel. And just so that you're aware, any request for an attorney to assist you in your field should be made within 42 days up to the 8th day.
Craig Lawrence was sentenced to 25 to 40 years in prison after being convicted on 10 counts of first-degree criminal sexual conduct and 7 counts of second-degree criminal sexual conduct. In addition to his prison sentence, Lawrence will be subject to lifetime electronic monitoring upon his release. How could a mother, in a fit of anger, put her own child's life at risk?
He was a minor. He was a teenager. He was afraid for his life. He thought he was going to die when his mother was at him.
On April 29, 2019, Elma Gray fired multiple times through her son's locked bedroom door during an argument at their home in Akron. Thankfully, her son wasn't harmed in the incident. After the incident, Elma fled the scene before the police arrived but was captured shortly after. The prosecutor's case was so convincing that they didn't just highlight a mistake, but exposed a dangerous act that nearly resulted in a tragedy.
Judge, we did file a sentencing memo, so I'm not going to go over the whole thing. I know you've read it and reviewed it. The state is requesting 6 years of ODRC. I believe that is appropriate in this case. It's a felonious assault. There was a firearm involved. Although we dismissed the specification as part of the plea deal, this is a very serious offense. The victim was the defendant's son. He was a minor. He was a teenager. He was afraid for his life. He thought he was going to die when his mother was at him.
Ms. Jackson, if you could talk into the mic.
Yes, Judge. And, she shot 3 times. This wasn't a warning shot. It was through the door. If you're trying to scare someone, I would imagine you would shoot at the ceiling, but she was through a door towards her son. And, I'm thankful that we're not here for a murder trial. For the reasons stated in the sentencing memo, state is requesting a period of incarceration. Judge Michael Gray, who is the father of the victim, is present with his attorney Leslie Johns, and I do believe at the appropriate time they would like to address the court.
Right, and I think that now would be the appropriate time. I would ask that whoever's speaking stands at the podium. Sometimes I would have you approach, but given the plexiglass and mic issues, if you could stay at the podium and speak.
The victim's father couldn't come to terms with what the mother had done to her own son. He gave a passionate statement to the criminal.
Your Honor, I would at this time like to allow my client, Michael Gray, an opportunity to speak.
Mr. Gray.
Thank you, Your Honor. I wanted to thank the court, the prosecutor's office, and my attorney for being there and protecting my son in children's services as well. I want to address Alma directly. The amount of anger and hatred I have towards you for what you did knows no bounds. I will be back in this court every 5 years and make sure that protection order stays in place so my son is protected. You won't understand the amount of anger I have until the day you die.
In advocating for probation, the defense attorney argued that mental health issues and a lack of support contributed to the criminal's actions.
The reason that we're here today is that, one, Ms. Gray has accepted responsibility for her actions, and this is truly a matter of where I don't think that this was a criminal case, but a case of crying out for help on Ms. Gray's part. The court has reviewed the psychodiagnostic reports and knows the significant mental health history, but during the time period, I think of what really pushed her over the edge was the lack of having a supportive helpmate, husband, partner, father, and what have you. As was indicated in Ms. Gray's PSI statement, she was offering by way of an explanation and not necessarily an excuse, in that, one, her family was going through financial help, her relationship with her husband, Mr. Gray, was on the rocks, and especially after he had given her an STD, her life was falling apart, and she had the mental health. It's in her PSI.
The judge highlighted the importance of both rehabilitation and punishment, stressing the need to protect the community and properly address the impact on the victim.
Having considered all of that, based upon the facts and circumstances of the case and consideration of the relevant sentencing factors, and applying the minimum sanction the court has determined will protect the public, promote the rehabilitation of, and punish the offender without imposing an unnecessary burden on state or local resources. On count 1 of the indictment, would note that this is an indefinite sentencing case under Reagan-Tokes, and therefore the court would impose a sentence of 4 to 6 years incarceration for the crime of felonious assault, a felony of the second degree. So the minimum prison term would be 4 years, and the maximum prison term would be 6 years. As we discussed when I took your plea, you will also be subject to a mandatory 3-year period of post-release control following your release from prison. When that period of post-release control is imposed, if you violate any conditions of that supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. Would note that the sentence is right in the middle of the guidelines for prison that could be imposed in this matter. And because it is her first offense, because of some of the mental health issues, I find that that is an appropriate sentence. Ms. Gray, there is a rebuttable presumption that you will be released from prison at the expiration of your minimum term of 4 years or on your presumptive early release date, whichever is earlier. If the Department of Corrections seeks to hold you longer, they may rebut the presumption that you will be released at the expiration of 4 years. If at a hearing the department shows that your actions in prison demonstrate a lack of rehabilitation, or that your behavior demonstrates that you continue to pose a threat to society, or that you were placed in extended restricted housing, that your actions demonstrated a lack of rehabilitation, or that your behavior demonstrates that you continue to pose a threat to society, then the Department of Corrections could seek to hold you longer. Or if you were placed in extended restricted housing at any time during the year preceding the hearing, or that you were classified as a security level 3 or higher at the time of the hearing. If the department overcomes the presumption, it may keep you longer than the 4-year minimum term, but no longer than the maximum term of 6 years.
As she was sentenced, the criminal showed no remorse for her actions. It appeared she was fully aware that she would have to face the consequences. Thank you so much for watching. Don't forget to subscribe and hit the notification bell so you can stay updated with our latest videos.